Good morning, everyone. I am here with Greg Mason. He is a trial attorney at the U.S. Department of Justice in the Civil Division Fraud Section. I am speaking with him today to talk with him about his experience as a government attorney. I'll be asking him questions about his preparation for law school, his experience in his career, and these are pretty straightforward questions. If you have other questions that you would like to ask Greg, you can always email me, and I will field those over to Greg. Good morning, Greg.
Good morning, Adam.
So I wanted to get started today by asking you a little bit about your background. I want to give the students an opportunity to know where you come from and how you got to where you are. So if you wouldn't mind telling us, where did you go to undergrad? Where did you go to law school? I think you and I share the same law school. About how long ago was that? And how did you get to this stage of your career?
Yeah, sure. So I went to undergrad at Lewis and Clark College in Portland, Oregon, which is a small liberal arts college, if you're not familiar with it, in Portland. I studied physics there and math, and primarily it was what I was good at. I had good math and physics teachers, and it wasn't necessarily a career-driven choice. It was more I found the subject matter interesting and sort of fell into it, to be honest. And then after graduating from undergrad, that was in 2004, so about 16 years ago, I sort of pursued a variety of different options. I thought about grad school for physics. I considered teaching. I did teach at some summer camps for a little bit, exploring that option, and had a couple other odd jobs. Eventually decided to go to law school, which is a bit of a dramatic shift from physics. I think that that was driven in large part by I wanted to have a career that was social, that was affected people's lives, that rather than physics, which sometimes can feel like you're sort of sitting in an ivory tower thinking about problems that only other physicists care about. I wanted to work on problems that affected other people's lives, and that led me to law school. I attended George Washington University for law school starting in 2006. So I had about a 2-year gap in between undergrad and law school, for those of you doing the math at home. Graduating, so during law school, I pursued a couple internships at DOJ. One of the great aspects of attending law school in Washington, D.C. or other big cities, but really in Washington, D.C., is the ability to do internships at federal agencies. So I did several of those during law school, and I think at that moment, or at that time, really wanted to pursue a career in public service, in government. But coming out of law school, ended up taking a job at, I'm probably jumping ahead in your questions here, but so I graduated from law school in 2009 and I took a job at a law firm in Washington, D.C., Drinker, Biddle, and Reith, doing commercial litigation, where I stayed for about 5 years.
Great. Let me go back to your undergraduate experience, because I just want to footnote something here. So you mentioned you were in a STEM field, and oftentimes students, and this is a question that students have all the time, they think that there's just one major that they should pursue when they are preparing for law school. And it sounds like you came from a STEM field, which is typically, a trajectory to things like patent work, preparing for the patent bar, things like that. Did you feel that you were at any particular advantage or disadvantage having chosen that career path versus like a typical quote unquote pre-law major?
I would say not really an advantage or a disadvantage. I mean, obviously, as you pointed out, if you're going to go into patent law or, other types of intellectual property law, but I would say particularly patent law, having a STEM background, having an engineering, chemical engineering, bioengineering, even mechanical engineering, and obviously computer engineering background, is tremendously important, or almost a prerequisite for some types of patent law. But if you're going that's not my career at all. I'm a litigator. We'll talk about a little bit more about exactly what I do later, but I don't work in patent law. So outside of that, I don't think that there's an advantage. Now there's a different type of education, of course, that you get studying science than you do studying humanities. Where I went to college, it's, as I said, a liberal arts college, and so even the science majors study humanities, and it's a liberal arts education. So it is a well-rounded education. I think that if you had a narrow, pure science background, that might be difficult to transition. But everybody's different. I don't think that there's any sort of courses that you take during undergrad that are necessary for going to law school. It's more, I think, about having critical thinking skills. Obviously, writing skills and reading comprehension skills are important, but it might be a misconception, but those are important in science as well. So, I think that law is a field that you can go into from any background. I don't think that there's one educational path that has the advantage or the disadvantage. I think that students in undergrad should focus on subject areas that they do well in, that interest them, that engage their critical thinking skills, that challenge them, and sort of the other pieces will fall into place.
Cool. You're saying all the same stuff I'm saying to students, which really reinforces what I'm trying to get across. So you're a commercial litigator, and you started out as a commercial litigator, and now you're a commercial litigator for the government. Talk to us a little bit about that. So what does it mean to be a commercial litigator, both in the private and the public sector? And then I'll talk to you just a little bit about how you got into the DOJ. But more broadly speaking, what does a commercial litigator do? What do you do on a day-to-day basis?
Yeah, sure. So those are great questions. Commercial litigation obviously is a really broad term. It encompasses all types of disputes that generally, as we think of it, commercial litigation that businesses find themselves in, availing themselves of the courts to settle those disputes or resolve those disputes. And so that can be anything. That can be intellectual property. That can be contract disputes. That can be fraud, that can be, negligence. It really can run the gamut. At the law firm at Drinker Biddle, where I was an associate, I really worked on a broad range of cases. Anything, my first case that I really dove into and took up a lot of my time as a junior associate was a negligence case revolving around a fire started by a construction company on a business owner's property. Not a typical case that you think of at one of these large law firms, not a sophisticated sort of white collar crime or anything that required in-depth sort of document discovery. It was a very basic negligence case. I also worked on cases under the False Claims Act, cases involving healthcare fraud, cases involving financial fraud, and which are obviously more complex, more sort of sophisticated in the types of analysis and argument that you have to do to either defend or try one of those cases. Now at the Department of Justice, my focus in commercial litigation is much narrower. I only affirmative work, meaning we're always the plaintiff. I only represent the United States as the plaintiff. In civil litigation, meaning we're not pursuing criminal litigation. My responsibility does not extend to any criminal cases, criminal liability, only affirmative civil cases under a couple statutes, but generally this one statute called the False Claims Act, which provides civil liability for companies that defraud the federal government, to use shorthand. Companies that submit false statements, lies, if you will, to the federal government in order to obtain money to which they're not entitled. And so, like I said, I'm always the plaintiff. So in the area of law, this is a much narrower focus, But of course, the federal government operates in so many different ways through so many different government agencies, Department of Health and Human Services, Department of Defense, Department of Energy, you name it. These are all different programs, different agencies that have different ways of operating, different types of different ways that they spend money, in other words. And so the sort of subject area that these cases can cover varies widely. It can be anything from healthcare to defense spending to grant programs, sort of you name it. If the government's spending money in an industry or in an area, you can sort of bet that there are people lying and cheating to get a little bit more of it than they're entitled to, and that's where we come in.
So you flagged this just a second ago, and I want to make sure we emphasize this for the students. You do civil work. You're not a criminal prosecutor. Nevertheless, you're representing the United States. Oftentimes, students think that if you work for the government in some way, it's some form of prosecution or enforcement. So, what does it look like? How are you? I guess how are you protecting the government's interests? Are these people being quote unquote punished for defrauding? Talk to us a little bit more about what a resolution of one of these cases might look like.
Yeah, so those are great questions. So it might be helpful to just talk through how cases come to us, what we do with them, and sort of lead up to how they're resolved.
Right.
Like I said, most of our cases come under a statute called the False Claims Act. And the False Claims Act sort of, in a somewhat idiosyncratic fashion, allows for whistleblowers to come forward with information and file a lawsuit on behalf of the United States. These are private individuals who have some knowledge that the United States has been defrauded, and they're allowed to file a lawsuit on behalf of the United States asserting those claims. And the large majority of my section's cases come to us through this type of whistleblower complaints. Whistleblower is not the technical term under the statute, it's called the relator, but to sort of explain the concept, it's what most people would commonly think of as a whistleblower, as I said. And the statute provides an incentive for these individuals to do so in the form of they're entitled to a percentage of any recovery that the United States obtains. So the majority of our cases, like I said, come to us through a whistleblower who has inside information. Usually this is somebody employed at a company that is doing the alleged defrauding. So it can be a health insurance company, for example, to put some meat on the bones. It can be a health insurance company that is, say, inflating diagnosis scores that it's submitting to the Center for Medicare and Medicaid Services to get more money from the Medicare program than they're entitled to. And an individual who works at that insurance company can come forward and say, I have information that this company is lying to the government and obtaining money to which is not entitled, and files a claim on behalf of the United States. Then I or somebody else in my office is assigned to that case and in charge of investigating it. Investigating this investigative work all comes in sort of a pre-litigation fashion, where our job is to determine whether the claims are meritorious, whether there's evidence to prove them, and whether ultimately whether the United States should intervene in the case, should take it over and assert not the whistleblower's complaint, but assert on behalf of the United States a civil action, which would then start litigation. So that's sort of the preliminary stage of my type of work, is we do these investigations that can involve agents from any of a variety of agencies, the FBI or Inspector General's office, the Post Office, or HHS, or Department of Defense, witness interviews, subpoenaing documents, the typical types of tools that you would use in an investigation. Often people think of in a criminal context, but in a civil context as well, those tools are available. We amass evidence and analyze that evidence and compare it to the statute to see if we can make out a case for civil liability under the statute. And if so, we intervene and file a complaint in federal court, which is sort of the beginning of a litigation, right? I mean, as an associate at a law firm, typically that's where an associate at a law firm in my prior career, that's where I would get involved. Is a complaint is filed and that starts a civil action. We're now in litigation. We're off to the races. And so then that's sort of the second part of my job, is pursuing those litigations. And there's obviously a long road between filing a complaint and any resolution, whether that's a trial or a settlement or alternative dispute resolution before trial. But typically, and the statute is intended to deter wrongful conduct. It's sort of a quasi punitive statute in that sense. It's not, nobody's going to jail, nobody's being deprived of their liberty, but the statute is intended to deter wrongdoers from lying to the government and getting money to which they're not entitled. And to that end, it provides for penalties, monetary penalties, and treble damages. So if we can prove $1 million, that the government was harmed by $1 million, the statute automatically entitles us to $3 million in damages. And so those two elements, the penalties and the treble damages, are intended to deter wrongdoers and to ensure that people who are dealing with the government do so fairly, do so honestly. But that, obviously, like I said, that doesn't always work.
Sure. So it sounds like you have the opportunity to work with lots of different arms of the government. What is that like to be, so to step up a little bit more general here, you would be called a government attorney, but what would you say are the similarities between you and other arms of the government? What is it like to work for the government as an attorney in any capacity? Obviously, it's unique to your situation in the fraud section, but are there any overlaps, things that you would say this is what it's like to work for the government versus being in like the private sector?
So from a day-to-day standpoint, the primary difference is as a government attorney, you certainly at the DOJ, and I think that this is probably true throughout any litigating section of state or federal government. As a relatively junior attorney, you're sort of given primary responsibility for a case in a way that at law firms, and particularly large law firms, you just aren't until you're more senior. At a law firm, you're working for a partner. The partner has a relationship with the client. The client, of course, cares deeply about the outcome of the case and has hired this partner to see it through. In the government, cases are assigned to you because you're the next up. You're the next person in line. A case falls on your desk, and you're the one responsible for it. There's no senior person above you who's going to care more about the case than you do. And particularly in affirmative work, by that I mean either criminal or civil, but where the United States is the plaintiff, is the party doing the suing. I think that that's particularly true because if the trial attorney, if the young government attorney, and they don't have to be young, I shouldn't say that, but if it's a junior role, right? It's not equivalent to a partner at a law firm. But if that person doesn't pursue investigative leads or doesn't pursue aggressive litigation, then nobody will. It's sort of incumbent on that person to do what's necessary to win the case, and nobody's really going to care more about the case than you do at the agency that you're representing or at DOJ working above you. So the relationship that a trial attorney and a junior trial attorney coming out of law school has to has to a case is totally different than an associate at a law firm who will be assigned tasks by a more senior member and asked to do certain things, but isn't the one driving the ship, if that makes sense.
Yeah. And I'll ask this question. This could potentially be a controversial question, but maybe we can keep it kind of above board. One question that students often have is, well, if you're a government attorney, you must just be this political person. So anytime a new administration, whether it's at the federal level or if you're working at the state level, a new governor or a new attorney general comes in, your whole life must be changing. Is that the case? Is it, you worked under 2 different administrations in your time at DOJ. How has your life changed much? Does it have an impact on you?
Yeah, I mean, Adam, this is a really common misconception. And whenever I tell people what I do and where I work, that I work at DOJ, I often get questions about the politics, the stuff that people are reading in the newspaper. And it's not really part of the day-to-day life of a trial attorney at DOJ. I can't really speak to the state, to people who work in state legal offices, but at the federal level at DOJ, the politics are really not part of the job. And the way that cases aren't assigned to us by sort of fiat or top down, from the president or the attorney general or any of the political appointees. Cases come to us either from agencies. I spoke earlier about whistleblowers coming forward with information, and in the other cases, agencies directly, they can have evidence either through an inspector general's investigation or otherwise of a potential fraud, and they'll refer those cases to us. And none of those are coming from any sort of political arm of the government. And the decisions that are made and how to pursue a case, whether to pursue a case and how to pursue it, are made by the trial attorneys. I mean, technically, the decisions are made by higher ups on recommendation of the trial attorneys, but it's just not the case that that those decisions are made in a top-down way. And I understand, it's what everybody reads about in the paper, and particularly now in the current administration. But I can tell you from my experience working in the Obama administration and then in the Trump administration, my day-to-day life has been generally the same. There are sometimes a shift in priorities, investigative priorities. I'll give you an example. The opioid epidemic has been, of increasing importance the last couple of years, and there's, probably some politics involved in that. Without getting into the politics of it, there probably are some politics involved in that an administration can decide, we want this to be a focus of this particular division or this particular arm of DOJ. We want you to focus on opioid related abuse, but not, so there can be sort of priorities in that sense, but not a go investigate this person or this company or, pursue a case against them, but not them. That it just doesn't happen. By and large, I mean, I read the same things that other people have read in the newspaper about that happening in certain circumstances, but I think that those are, certainly the exception, not the rule.
That's a thing that I try to communicate to the students, which is that the government's very much like an iceberg. We see the little tip of it, and all the big things are quote unquote happening, but the vast majority of the work of government is happening below the surface. And it's folks like you that are keeping the wheels of government moving on things that most Americans probably aren't even paying much attention to.
Yeah. I mean, for better or worse, that's right. I mean, my office, just to give you an example, it has about 110 attorneys in it, give or take, and none of them are political appointees. Nobody down the hall is a political appointee. There's a political appointee who's sort of my boss. The director of my division's boss is a political appointee. Okay. And so there are times when we need authorization to do certain actions. there's there's a very sort of formalized list of what actions require different levels of authority.
Okay.
Authority is sort of delegated down, obviously from the president to the attorney general, then further down the list. And so a lot of the day-to-day stuff has been, the authority level is delegated down to career attorneys. So the director of my office is a career attorney, trial attorney, not a political appointee. There are certain actions that require authority of the political appointees, but that's not the sort of day-to-day part of your life.
Interesting. So let me ask you, these last three questions are a little bit more personal. They're very general. So the first question I'd have is, if you had to pick one thing that you really enjoy about working for the government, what would it be?
Well, I think that the best selling point, I guess, from like I'm not trying to sell it, but the best sort of selling point to a young attorney or aspiring attorney is, working for the government, working for DOJ. It sounds corny or cheesy, but we really do believe in doing justice and doing the right thing, not necessarily in just maximizing the best outcome for our client, which is a real shift from private practice, where as a lawyer representing a private client, your duty is to your client, sort of first and only. Obviously, you have duties to the court, duties to be candid to the court and all that, but within ethical bounds, your duty is to sort of maximize the outcome for your client. And at the Department of Justice, we really do believe, again, it's corny, but we really do believe in it, in seeking justice. And so, we don't just try and seek the maximally best outcome for our client. We do try and pursue justice. And that's empowering, I think, as a trial attorney, to have that as part of the calculus, to be able to make those decisions. And it can also affect your morale and work, but it also affects your sort of work-life balance. It affects everything. I mean, if what you're allowed to do then is sort of at least help shape the types of cases that you work on. Because if you don't believe in a case, you don't think it's a good case for one reason or another, it's not your choice. I mean, you have to sort of formalize it through recommendations, through memoranda up the chain, but you can help shape what types of cases you end up spending your time on by letting that consideration of what cases do you believe in help guide the choices.
That's good. In terms of advice that you would give for someone, let's say you're an undergrad who's wanting to potentially work for the government in some capacity, and obviously that could be state or federal or whatever, but if you had recommendations to give to somebody about charting that career path, what are some tips that you might want to consider at that undergrad stage?
Yeah, I think that one of the most important things to sort of develop is any sort of background in public service. I mean, it can be a non-legal type of public service, but one of the things that hiring officials at DOJ and at other government agencies look for is this the type of person who believes in public service? I mean, I think that it sort of goes without saying, but I'll say it anyway, that obviously there are trade-offs to working for the government, and one of the biggest ones is financial. I mean, lawyers at DOJ are compensated fine. I don't want to sound like I'm complaining about the compensation, but of course there are financial trade-offs as opposed to working at a private law firm. And so I think that demonstrating or sort of showing hiring officials that you're the type of person who cares about more than just that you do believe in public service goes a long way. So, I mean, obviously that can be a variety of different ways. People with a military background, of course, sort of goes without saying. have that. But anything, I mean, did you volunteer in your spare time? At did you work for public service, non-legal jobs during your summers, or anything of that nature?
Okay, good. And then if you could flash all the way back to the summer before fall 2006, and you were wanting to know if you were to be able to go back and tell yourself, what are some things that you wish you had known at that time that you would like to be able to tell yourself now about, and not just going into government, but also going to law school, preparing to be an attorney? Are there any things that you wish you could go back and say, think about this, whether good or bad?
I should have a better answer for this. You know, I think that it's sort of my nature to look back on every decision I've made and wonder, and I think a lot of people are like this, to wonder, oh, what if I had chosen this? What if I had chosen that? I think that one thing to keep in mind is that, there's a shift, and it's not always perceptible when it happens, but you're young, you're going into law school or maybe coming out of law school, and you have a million options, or maybe it feels like you have a million options. Those options don't stay options forever. So it's true that you can have a bunch of open doors to you at 22, 24, 26. But you shouldn't assume that those doors will stay open forever. So I encourage people to, explore a lot of options, especially when they're young, because generally, I think at that age, you don't necessarily know what you want to do with the rest of your life, and that's fine. But also have a realistic sense of when you make choices about pursuing one thing, you are sometimes foreclosing pursuing others. So just be realistic about that, I guess would be my advice to my former self.
Yeah, if there's one things that my students know, it is that that I try to tell them is that your 20s the clock is ticking, and you need to be making some decisions fairly early on.
Yeah, otherwise those decisions are made for you.
That's right, exactly. Well, thanks very much, Greg. I really appreciate you talking with me today. And as I say, if students have questions, I may field those to you through email. But this was a really rich conversation. Thank you so much for talking.
Yeah, my pleasure. And don't hesitate to send Adam questions my way.
All right. Take care, Greg.